assumes that the defendant knows of.
Correct. And so my position is that at this point, I think it's too attenuated. I think there's too much of a stretch at this point, and especially since he didn't witness it, and he didn't witness when she was specifically told about it. He just assumes that she knew.
He's simply speculating that she knows about it.
Correct.
Judge, first of all, I'd suggest that we proffer his testimony on this issue. It's going to be brief. He actually witnessed the injuries. He didn't witness, most abusers aren't.
He though, not her. But how does that bridge the gap from
fix what she said
his knowledge to her knowledge?
I want to fix what she said about the basis of his knowledge. His knowledge is he witnessed injuries. Most abusers aren't going to abuse their children in front of someone or have a witness present. And then he's going to say the family discussed this over the years. In fact, at the time Joey ran away, where Mr. Lear has already testified he bought Joey the bus ticket to come down here, he was fleeing abuse. And that Nicole was around at the time and was aware that that was the reason he was fleeing. And I have cases here that show
How does he know she was aware?
He says the family discussed it. It was happening in the home.
Well, bring him in. Bring him in. Let's see. If it sounds like it's a assumption on his part and speculation on his part from what I'm hearing from even both of you. But let's bring him in
and I do want to also point out, and I want to cite Nelson v. State, and I didn't give this one to you, Mr. Intern. So just for the record, cases are Williams v. State, 982 Southern 2nd, 1190, Quintana v. State, 452 Southern 2nd, 98, and then Nelson, which says that hearsay, reputation evidence can come in through hearsay testimony. It does not have to have been personally observed, meaning Nicole Nachtman didn't have to witness the abuse. People could have told her about it, and that's sufficient.
But there has to be some evidence that she knew about it.
It is.
Not just, I believe she knew about it, I think she knew about it, I assume she knew about it, she should have known about it. She knew about it because I told her. She knew about it because she was there when we discussed it.
Yes, sir. I can elicit those questions from Mr. Lear. And Nelson is 739 Southern 2nd, 1177.
All right, Mr.
I
Terry.
have copies for you if you want them.
I want to correct one thing that,
Yes.
that Ms. Hersey just said that I found out about last night, subsequent.
Yes.
Mr. Carey called me and indicated that Eric Lair is incorrect about the running away. He never ran away from his mom. The time he got the bus ticket from Eric Lair, he was running away from Texas. His mom was already in Tampa. He was running away from Texas where he was being abused by his father. And he was having to be there on an extended summer visitation. And so that's what he was running from, not from his mother. And so to say that they were discussing it because she was abusing him and that's why he ran away from her, he never ran away from his mother. He stayed in Tampa when she was moving to Virginia because he didn't want to go there, but he never ran away from his mother. He ran away from the father, and I intend to call him in rebuttal to bring that up to explain to the jury the actual circumstances. It was his life. He remembers it, and he knows exactly what he was fleeing from. So I wanted to correct that for the record and let the court know that we intend to bring him back on rebuttal to explain that situation.
Well, I appreciate that because there was some confusion in my mind from when he testified and then from what was explained subsequently, and I was confused as to whether I got the impression he had run away from Tampa from his mother. But if that's not the case, then...
He ran away from Virginia and Tampa, and his sworn testimony
Wait, you said Virginia and Tampa, or Virginia?
No, he ran away from Virginia to Tampa.
To Tampa.
Got out of the car. Well, Mr. Terry, when he asked him, you didn't really run away, like we made this big issue about the word run away, he certainly wasn't staying in the home. And Judge, while we have this discussion, I'd ask that Mr. Carey not be in the courtroom.
Yeah, that's fine. I'll ask him to step out just till we finish this legal argument. Thank you, sir.
Sworn testimony under oath at a deposition and at the battered child syndrome hearing is he ran away to get away, and I asked him on cross yesterday, he ran away to get away from the stress and turmoil that was happening in his household between Ronald Nachtman and his mom's volatile relationship and the divorce that his mom and his father were undergoing. That's his sworn testimony. He may now want to couch it in terms of, I was running away from my abusive dad, which again, we weren't able to get into because the state objected that that wasn't relevant. But his sworn testimony is, I was running away to get out of that household that involved his mother, who was going through a custody battle with Nicole's father, and going through a divorce by his biological father. That is what his testimony is.
Those sound like cross-examination questions, and those are things for the jury to decide, not me.
Absolutely.
Just like the self-defense thing, I'm not deciding that it's just that you can argue it to the jury and they can decide it. I'm
Yes,
not
sir.
deciding it. So I appreciate that information, Mr. Terry, for the benefit of everyone, and decisions can be made, down the road as to whether that's necessary, not necessary.
Judge, I don't know if you want to do Eric Lear or what order, but the other outstanding issue is we have my motion in limine as to the expert testimony, and because the experts are going to happen today, all of them, I prefer that we have a ruling. And I think when Mr. Terry and I initially talked about it earlier in the week, or last week, I think he was under the impression that I wanted Dr. Lazaro prohibited at all from talking about what Nicole told her about the offenses. My request in the motion in limine was that she not be able to characterize anything as a lie.
Right.
That's improper for an expert to do. It's improper for the jury to hear her opinion. She can testify, and I clarified it with Mr. Terry, so I'm not sure what his position is on the motion now, after we talked about it on Monday of last week.
Yes, Judge, she won't, I'll instruct her not to say lie, but she can say that there was inconsistent
Absolutely.
statements. And she's
Well,
gonna say,
it's not consistent with the evidence, and that was my thinking when I read it.
Correct.
Can't say, because she's not an expert
I will-
on credibility, but she can say what she reported to me is inconsistent with what, I know about the case, the police reports, absolutely, inconsistent, but not say, in my opinion, she's lying about this.
and I will advise her of that, Judge. I don't have an objection to that. I will
So
advise
Judge,
her.
that covers, just of my motion, I don't know if it's in front of anyone, that covers paragraphs A through F. G, Dr. Lazaro, despite Ms. Nachtman participating in a 14-hour evaluation, opined that she believes my client was being uncooperative during the evaluation because she was lying. Again, uncooperative and not answering questions.
The conclusions, she can testify to observations that she made. I asked her questions and she refused to
Right.
answer those questions. Absolutely.
But to say she's uncooperative because I think she was lying, which is how she testified at deposition, I'd argue should not be allowed.
That's fine, Judge. I don't have an objection.
So
Alright.
G.
There was something about grandma too.
H was Dr. Lazaro testified that she believed that Ms. Nachtman was hoping the interview on the second day wasn't going to happen and she wasn't going to have to do another interview. There was no such words
Sounds like
uttered.
speculation. I mean, Mr. Terry, did you?
I don't intend to get into that. So.
All right, so she won't testify about that. That she thinks that Nicole thought the interview was going to end on the second, and it went into the third day. We won't go there.
She opined in deposition that the defendant lied about how well she really did in school. Again, if she wants to talk about school records she reviewed and what the grades
She can
showed.
testify. Nicole said that she was doing great in school. However, her report card has F's on it. But to say that she was characterized it as a lie, she can present the facts. The jury can decide later whether she was lying.
Okay.
And that was I. J, when describing an incident at graduation where Ms. Deans pulled my client to the side, Dr. Lazaro indicated, again, she did not believe that that's the way it occurred, the way the defendant described. Obviously, Dr. Lazaro was not at Nicole Nachtman's graduation. So to characterize, again, anything my client is relaying about instances with her mom, to characterize that she believes or disbelieves any of it is completely inappropriate.
What's your position on that one,
Well,
Mr.
Judge, one of her positions is that she's malingering, and by malingering, she's not saying that she's malingering any mental symptoms. What she's malingering is the amount of abuse and what she suffered. And so, in order for her to give that opinion, she needs to state that she does not believe it occurred the way Nicole was describing it. It does not sound right. And so that's part of the entire malingering aspect, and I think she should be allowed to testify about that. Obviously, she won't say she wasn't lying, but she can give her opinion as a certified licensed psychiatrist that she believes that was not how it happened.
Judge, the way malingering works is she can testify to a test she administered on malingering. She can testify to the questions that she asked Ms. Nachtman and in what areas she scored in malingering. But again, we're back to square one where she's now going to characterize Nicole's reports of abuse as, I don't believe that it happened that way, when there's no evidence to suggest that that opinion is true. Her opinion on malingering can absolutely be based on tests she administered as it relates to malingering. She can testify to the scores. She can testify to Nicole Nachtman malingered here, didn't malinger there. What she cannot do is say that anything my client said, unless Dr. Lazaro was at the graduation, that report is false. Unless, again, back in the records or the family's accounts are different, she can talk about inconsistencies and maybe how that incident happened or how Nicole described it versus the records. But to opine that she doesn't think she's telling the truth about how it happened, where's that coming from? That's not based in any
Well, your
expertise.
experts weren't there when Nicole shot her parents, and they're going to make opinions about whether they think she was in fear or whether they think she was hallucinating at the time, but they weren't there. So how about if I preclude those opinions?
Based on words my client uttered, that's their opinion. Dr. Lazaro's belief that it didn't happen isn't based on anything. Nicole said it. If Nicole had said it didn't happen, or if
But
Nicole...
it has to be based on something. She didn't just come in there and say, you know, I mean, it has to be based on something. I mean, if not, then hey, cross-examine the heck out of her on it. That's what cross-examination is for. If that's what she says, and I don't believe it happened that way, and then you get up and you say, what's that based on? She says, nothing. Oh, great. That's a score for the defense.
Well, but the jury has now heard an expert psychiatrist's opinion that she doesn't believe my client's account.
And
Again,
then
it goes
on
back to the...
cross-examination, they heard that expert say that my opinion is based on nothing.
Okay, so you're
I'm
denying
going to allow
it
it,
as
yes.
to
You
paragraph
cross-examine
J.
her. You cross-examine her on it.
Okay, so right now we're on A through I. My motion in limine is granted, Your Honor.
Yes,
J, it is denied.
yes.
Paragraph...
Well,
50
wait. Partially. She can't say, use the word lying. She can say that it's inconsistent. She has to base it on. She has to explain why.
Okay.
Do you understand that, Mr. Terry?
Yes, sir.
Okay.
Paragraph 15 in the deposition indicated she was unable to diagnose Ms. Nachtman with antisocial personality disorder because she didn't meet the criteria. She then gives an explanation. Oh, she didn't meet the criteria by one thing. This jury shouldn't hear antisocial personality disorder at all because she can't diagnose it because she doesn't meet the criteria. It's prejudicial for an expert to be able to say, well, I think she was antisocial in A through G, but I didn't diagnose her with that because she didn't meet F. It's prejudicial because she can't come up with that diagnosis. So any mention of any antisocial personality disorder is irrelevant, and it's not her opinion.
But at the end of the day, I mean, she's saying that she's not. She doesn't have that.
She is, but I don't want the jury to hear antisocial personality disorder at all. It has a negative connotation, and if she's not diagnosing her with it, what's the relevance?
Does schizophrenia have a negative connotation to it? I mean, your experts are going to say that
She's
she's
going to say
schizophrenic.
schizotypal. She's going to say she's on the schizophrenia spectrum. So everybody's on the same spectrum. We're just a little off on the spectrum.
She needs to be able to give her opinion as it is and say,
Well, but-
this
but
is what she met. She met all of these criteria but one. So while I believe it, she may be, but I can't absolutely say for certain she is. But I mean, these criteria, Judge, are very flexible and very hard to pinpoint. As you know, they're all like 8 criteria. Should meet 3 of them.
So
And,
essentially,
you know,
she's an attestation. It's not black and white.
it's not like right. She can't. She's not going to say that, but she can say that she meets some of the criteria for that.
So
That's
she
incorrect.
thinks that she still might be, but I mean, because
I mean,
what the
I'm having
defense
to
is
go from
telling me
memory
is
from a deposition that was a while ago,
That's
so I don't remember
incorrect. She
exactly
didn't
what
say
she
it was
said.
fuzzy. She cannot diagnose her with antisocial personality disorder because she did not have a conduct disorder before a certain age in childhood. That is her testimony. She is not antisocial. So to then say, well, I looked at antisocial personality disorder, but I can't diagnose her with that because she doesn't meet it's a requirement for antisocial personality, that you have a conduct disorder at a certain age. She admitted in deposition that that is an actual requirement before the diagnosis can be made. And I'll quote the exact deposition, page 117. Do you believe for malingering I asked, because did you diagnose her with antisocial personality? Let me say something about that. No, she didn't meet antisocial personality criteria only for the reason that you need to meet the criteria for conduct disorder as a child. That's what Dr. Lazaro
Well,
said.
Judge, it sounds like she's not going to say it. That was in response to their question whether she asked it.
So
I'm not
you
gonna-
don't intend to
I don't
elicit-
intend to ask it. So
Oh,
I
that's
mean,
the question. I don't want it mentioned at all.
Okay.
I have no intention of asking her.
Okay.
I'm merely going to ask her diagnosis and
Okay.
what she found. And she gave I believe 6 of them, and I'm going to go through each one and ask her.
obviously the deposition is much broader than things she may testify to
Right.
here. Sounds like during the deposition, the defense was going down different avenues and different doors were closed. If that door was closed as to antisocial personality, then I'll instruct the state not to elicit that.
Well, and it sounds, and I won't. But that sounds like they. I didn't know, Judge. It's been a
Right.
while since we've done the deposition. We've done so much since then. So I
So
wasn't
granted
sure.
as paragraph 15, Your Honor?
Yes.
16, during the evaluation, well, let me ask you, are you intending on asking her about watching this series that my client liked, this television series? She indicated it was not relevant to her opinion. The term the TV series in and of itself, in the title, I didn't want mentioned unless she was
I think
relying on
Mr.
it.
Terry's indicating he has no intention.
Granted as to 16.
Okay.
And then the final one is the
Grandma.
information about the grandmother. And again, my position on Miriam Lear is Dr. Lazaro did 2 interviews of family members, the grandmother and Joseph Carey. And when we deposed the grandmother right after the interview, shortly after, about a week after I think it was, and asked her the facts that she relayed to Dr. Lazaro. So, for example, Dr. Lazaro says you told her this. She has absolutely she's 88 years old, or 89, I think the testimony is. Obviously, the state has chosen not to call her as a witness to lay any foundation for that opinion, so we'd be arguing that would be hearsay. Had they called Miriam Lear, and she had testified to whatever she remembered, or was even as we sit here today able to remember it, my argument would be different. But because she wasn't called as a witness and has no recollection of the information she shared with Dr. Lazaro, we'd ask that she not refer to that interview at all.
Judge, I believe she should be allowed to refer to everyone she spoke with in forming her opinion. Whether or not Ms. Lear remembers things certain days, doesn't remember things other days, is I believe, immaterial to what Dr. Lazaro heard and based her opinion on. And I believe she's merely going to testify that in speaking with her, that Ms. Lear did not notice any problems with Nicole that drew her attention, or did not see any negative relationship between the mother and Nicole. That they seem to be getting along fine. In fact, she described, and she also, I believe, described this in the deposition as well, that just right before then, like the week before, she remembers them both being in the house, and that they were sitting together on the couch, and Miriam was sitting on the armchair next to Nicole with her arm around. They were laughing and joking about stuff. So, and she said that in the deposition as well. She did remember that. So that's one of the things Dr. Lazaro relied on. So I believe she should be allowed to at least testify about it. If they want to get into the fact that, what her mental situation is, they can.
Well, Judge, it goes back to the argument they've been making about our hearsay information. They don't have a right to confront witnesses. We do. So if you allow Dr. Lazaro to be a conduit to Miriam Lear's information, we didn't have an opportunity to cross-examine Miriam Lear on her lack of memory now because Mr. Terry didn't call her. We can't call her to impeach her. We can't call her to say, hey, you don't remember anything. He doesn't have a right to confrontation. We do. So now to allow Dr. Lazaro to be the conduit to Miriam Lear's hearsay is a violation of Ms. Nachtman's confrontation rights, because now it's left for the jury. She told me all this stuff, and a week later when I deposed her, she doesn't remember anything. That's the violation.
All right, but the doctor should be able, if the doctor took it into consideration, the doctor should be able to allow to say, I spoke to A, B, C, and D, and based on what they told me, this is my conclusion.
Fine. But to talk about the hearsay that was then relayed to her that has not been established violates Ms. Nachtman's confrontation rights.
Judge, I don't know what she's going to testify about that because she was never asked questions about that in the deposition. I don't necessarily intend to elicit anything more than just to who she spoke with, and that's it.
And I'm going to allow that, and you're entitled to that. Now, here's my ruling. She can't get into specific statements because I think that those are most likely hearsay, and I know that the case law says the expert can't just be a conduit to hearsay. Now, if there's some other exception to those statements, then I would be happy to consider them, but I haven't been presented with any. So for the doctor to get up here and say, Grandma told me, quote, whatever, I'm gonna sustain or grant the motion limited to that. But as to the doctor talking to her, basing her opinion on what the grandmother told her, absolutely.
Thank you, Judge.
Is that all?
Yes.
And Judge, I'm obviously going to need some time to speak with Dr. Lazaro about those things.
Well, she's not being called right now, is she?
No, she's not. She's not.
Yeah.
2 other matters,
We're being optimistic that we might even get to her today.
I believe that is going to be optimistic, Judge. But 2 other matters. Number 1, I've informed Dr. Lazaro of the rule. She's aware of it. She has not been watching any testimony or anything like that. But what I need to know is she has asked me because, as Your Honor's going to find out, Dr. Heidi is changing her opinion on insanity. Obviously, I never got a chance to depose her about that. I never found out why she changed her opinion, or because I found out about this literally on the Friday, the eve of trial. I received a phone call from Ms. Cersei Folguera. So I'm kind of going at this blind myself. And Dr. Lazaro would love to know, or is curious to know, why she changed her opinion, what she now truly believes.
I think she's entitled to that.
So she would like to watch that online wherever she's
an expert. I don't. The rule of the experts can sit in here and watch.
I don't think that's precluded. But
Yeah.
my issue on the insanity, and we might as well address it now. just so the court knows the sequence of events, we filed a notice of intent to rely on insanity, which we're required to do by Rule 3.216. The only doctor we listed to elicit an insanity opinion is Dr. Ewing. Dr. Heidi, in a battered child syndrome hearing, was asked one question about her opinion on McNaughton, and she indicated no. In trial preparation, in discussing Dr. Heidi's testimony, and in reviewing the jury instruction with her on insanity, she indicated to me that she, under McNaughton, would have believed Ms. Nachtman, and I'm paraphrasing, I'll let Dr. Heidi testify, that under McNaughton, yes, she believed she knew it was wrong, but she was going to discuss the consequences. Well, I didn't amend my notice. I do not intend to elicit an opinion on insanity from Dr. Heidi. And I let Mr. Terry know that. Because of the late time in which I found that out, I was not going to then amend my notice, because we have time period constraints on when we issue a notice of intent to rely on insanity. So I do not plan on eliciting that opinion. As my ethical obligation is, I let Mr. Terry know because I didn't want him to ask her and be surprised if she changed her answer. Mm-hmm. But I don't intend on eliciting that, and I don't believe it should be asked by Mr. Terry. I have a notice requirement as it relates to insanity. I would have added Dr. Heidi if I had not found out the week before trial, and I didn't. I don't plan on even asking her about insanity. So to then now ask her about insanity on cross, it's beyond the scope of Direct A, or will be at that point, because I will have not elicited an opinion, and I purposely didn't put her on the notice because of the late hour in which I learned it. But as my ethical obligation is, I let Mr. Terry know so he wasn't surprised by that when she testified.
Yeah, well, she's I don't find it beyond the scope. I understand that technically it's a different, legal term of art as to insanity, and I don't mean to overgeneralize and say that they're the same thing. But she's talking about the same issues here, so I'm not going to preclude the state from asking her that on cross. Now, what I'm going to ask is that you make her available to them. I know it's not a deposition, but allow the state an opportunity to talk to her before she testifies.
Judge, I never precluded that
about
from
that.
When I
and also, absolutely, Dr. Lazaro can either come down here and watch, she can watch on the live stream, but she can watch the other experts testify. Both of them, yes.
I'll let her know then, Judge.
And there's no objection to that.
No, just their experts are allowed to sit in.
Right.
And then there's two other matters with regards to the expert's testimony that are just very briefly, two things that I want kept out. Number one, Dr. Heidi, when she testified previously, Judge, in your Honor's courtroom, she stated that...
Let's let the other witness know. He can come back in.
Mr. Carey?
Yeah, I don't have...
Do you want him out for when Eric proffers?
Yeah, I'd
Judge,
prefer him
please,
out.
I'd rather
all right, that's fine. That's fine.
Judge, I would ask that Dr. Heidi be precluded from discussing any prior abuse done by allegedly done by Mrs. Deans against Joseph Carey. And I would point your Honor or point the court to page 60 of the transcript of proceedings before the court, and where she talks about those issues. And obviously we were in a court with you, Judge, so I was not going to necessarily object at that moment. But even in talking about Joe being, talking about Eric Lear's testimony, it's kind of fitting that we're actually talking about it. She describes the abuse that Eric Lear talked about, and she then indicated, so that data, though not directly relevant to Nicole, certainly indicates behavior that I would consider to be physically abusive towards, in that case, another child. I would ask that she be prohibited from discussing any evidence she knows or has heard about or read about regarding any alleged abuse between Miriam Deans and the other son, or Joseph Carey.
Oh, just, okay.
And then the other thing is on in Dr. Ewing's deposition, he mentions, I'll see if I can find the exact page number, but he mentions in that deposition that the mother obtains a gun and tells Nicole that she got the gun because, according to Dr. Ewing, which I guess he received from Nicole Nachtman, black people were moving in the area and they needed it for protection. We would object to that statement.
Nicole reported this to Dr. Ewing, that her mother got the gun for that reason?
Correct. I'll see if I can find the exact page number. I had it written down.
And you want to preclude any,
Judge, I believe the court, I'm not so much about the gun, but the purpose of the gun.
right.
Let's go find the page number. It's on page,
Ms. Hershey, did you intend to get into the specifics of,
I don't think the reason she got the gun is relevant.
all right, that's
Okay.
sustained.
yeah.
So you cannot testify to anything that Nicole told him about why her mother got the gun.
But just that she got it.
She got a gun. Even
That's fine.
she got a gun for protection, but not the specifics of.
Right, not the specifics, because the state feels that's overly prejudicial. And that was all I have regarding
I would
those
agree.
at this point.
I would agree.
Judge, the issue on page 60 about abuse, Dr. Heidi's comment that it's not relevant to her opinion on battered child syndrome doesn't mean it's not relevant to the issue of self-defense, and that's for the jury to decide. So I don't believe that while she may have testified, when she's testifying to whether something's relevant, it's her opinion as to battered child syndrome. She shouldn't be precluded. If in fact we can establish that Nicole Nachtman knew about these specific acts of violence and they come in, I think she can testify to records she reviewed to corroborate it, if I can establish it.
If you can establish that Nicole knew about
Absolutely.
them, that's a different story.
Yes, sir.
But we haven't established that.
Yes, sir.
All right. So did you want to proffer Eric? That's what I thought. All right. Let's. We ready to bring him in anyway?
Yes.
All right. Let's bring him in.
You want to come up here? You want to come up the,
Yeah.
okay.
Good morning, sir. Welcome back. You'll come on back down to the stand. I'll remind you, you're still under oath from yesterday. Before we bring the jury out and continue with, I guess we are going to go back to, you're going to reopen for direct regardless of what happens with this, is my understanding? You have some other stuff, or just
No,
this?
I was gonna only reopen
Just
for
this?
direct if this was,
All right, well, we need to get some information from you, sir, outside the presence of the jury, so I'm going to allow Ms. Hershey to ask you some questions.
Mr. Lair, yesterday you discussed an incident in which you bought Joey Carey a bus ticket when he ran away from Virginia and came to Florida, is that correct?
Correct.
And what was your understanding as far as what the purpose of him running away for, or why he was coming to Tampa?
He told me he was being abused by his mom and dad. And I asked him what happened. And he said that previously they had broken his arm, they had flushed his face in the toilet, they had made him sit on a heater. I mean, it was enough for me when I heard that much.
So you purchased the bus ticket for him and he comes from Virginia to Tampa.
Yes.
Where is Nicole at that time? Does she remain in Virginia?
Well, she didn't come with him, so.
Okay.
Yeah.
What, if any, other instances of abuse are you aware of? First, let me ask you that you're aware of as it relates to Miriam Deans and her son Joseph.
When Tampa Bay Mall used to be there,
Well, let me stop you.
Oh.
I don't mean to. When he came back and when you got him the bus ticket and he arrives in Tampa, did you notice any injuries consistent with the abuse he had described to you?
no bruises or.
Like he didn't have a broken arm at that point? These
No,
were things that had
he
happened
said
before.
previously. Yeah,
Okay.
yeah.
Tell me about any times where you witnessed or became aware of abuse by your sister on Joseph.
One time he called me from Tampa Bay Mall when it used to be there. I'm not sure. I think he was maybe 10 or 11. I'm not sure how he was. Not driving age, so he was younger. And he told me to come get him. And I said, "What's going on?" And he said his mom drove a key into his forearm and left him at the mall. So I told him I'd be there to pick him up. And I
And
did.
did you then see an injury that corresponded with something consistent with what he had described to you?
Yeah, he had a I don't know if it was a deep scrape or, it was just, there was blood there. It wasn't like requiring stitches or anything like that, but it was pretty scraped, and it looked like somebody just keyed him, yeah.
Any other instances of abuse by Miriam on Joey that you're aware of or you know of?
Just what he disclosed, just what he disclosed over the phone to me when he was running away.
Okay.
Um,
And
other
then the
than that-
mall, anything else other than the mall and the phone running away?
Not that I recall.
Now, I want to ask you if at any point, whether when it happened, after it happened, at any point in Nicole's life, are you aware of whether Nicole knew about these instances? Did she know about the running away and why? Did she know about the mall incident and the key incident? If you know.
I'm not sure specifically. I know that one time we were discussing about things that had happened to Joey at the hands of his mother.
Who was discussing?
I was talking to my mother. Nicole was there on the lazy boy, and I think my son might have been there.
Hunter?
Yes.
So there was a period of time where your mother, Miriam Lear, Nicole, and your son Hunter and you were in your mother's house.
Yes.
And tell me what was being discussed about the abuse of Joey in front of Nicole.
Because she had arrived, and she looked.
Who's she?
I'm sorry. Nicole arrived there, and she just looked upset, or she looked upset. And I said, "What's wrong?" And she said, I can't. She just kept saying, "I can't." So I guess she couldn't tell me what it was. Then, because she had confided in me once before about her mom hitting her, I felt she couldn't trust me, because I think it came back to bite her after I confronted my sister about it.
So Nicole had previously reported some form of abuse by her mom.
Yes.
She tells you about it, and you went to Miriam about
I
it.
confronted my sister about it.
And Nicole didn't want to tell you this second time because I guess she felt you were going to go to her mom.
Yes.
So tell me what the discussion is at that time about the abuse of Joey, or what was said about Joey in front of Nicole about anything Miriam may have done to Joey as a kid.
Well, I said, "You're aware that you can tell me because the same things happened to Joey." And she said, I can't. She wouldn't tell me.
And when you said the same things, you meant she was physical or somehow
right.
physically abusive.
Yeah, because it was related to how my sister treated Joey, which resulted in him running away.
Judge, I don't have any other questions.
Do you have any questions?
Yes, Judge. Mr. Lear, that last statement you just said, you said to Nicole, "You can tell me because the same thing happened," and then you indicated what you meant. You didn't actually say what happened at that time, did you?
Not didn't describe it, no.
Okay. And you said when you began this conversation that Miss Hersey Folgera asked you when this was discussed in front of Nicole, and your response was, "Well, I'm not sure specifically, but I think it was at my grandma's house on one occasion." How old was Nicole?
She was driving, what's it called, age?
Okay, teenager, 16 over.
Oh, yes, at least.
And this was a conversation at your house.
At my mom's house.
And it was on one of these occasions when Nicole came to the house.
She showed up there.
And the specific acts of abuse were not discussed, just the same thing happened to Joey.
Yes.
And the reality is you don't even know if Nicole was actually talking about abuse when she said, "I can't," do you?
Correct.
Okay. You don't know if she was just talking about Miriam screaming at her or verbally yelling at her, do you?
No.
Okay. So to say the same thing happened, that's not indicating physical abuse or otherwise, correct?
Correct.
Okay, and I want to go back a moment. You said earlier that Joey told you about when he was abused by mom and dad, and you asked what happened, and your response was that previously they had done things to him.
Correct.
Okay, but I want to clarify, because when you gave a deposition in this case, your specific statement was that my brother-in-law took his face, put it in the toilet, would make him sit on a heater, one of those heaters, and broke his arm one time too. So you previously said it was just your brother-in-law that had done that to Joey, correct?
If that's, I don't have my,
Can I approach him, Judge,
Yeah.
if I may? All right, I'm going to show you what I'm reading, if you want to start up here at page 1, yeah, take your time. And for counsel, I apologize, I'm on page 24 of his deposition, lines 1 through 8.
Yeah, yes, that's correct.
Okay, so at that
Because I'd
time.
asked that he be asked to read the whole paragraph. 'Cause
Sure,
the first-
well, and I'll read it, that's fine. It said, and according to Joey, he told me that the father and my sister were abusing him, comma, that my brother-in-law took his face, put it in the toilet, would make him sit on a heater, you know, one of those heaters, and broke his arm one time too.
Correct, but okay.
And then you went on to say, and that the same treatment was being applied to my sister by the husband.
Correct.
Okay. And the only reason, I understand that you said that your sister was abusing him too, but those specific acts that you just mentioned here in court, you indicated those were by your brother-in-law.
In the deposition, I did say that, but I guess I wasn't asked specifically who did what, because when I spoke to Joey on the phone, and I had asked about my sister, because I'm like, why can't you stay with your mom? It was like, they're both doing it.
They're both doing it.
So I wasn't sure which one broke the arm. It was just a combination of everything that's been done to him under both their care.
When was this conversation with Joey?
When he I think a day or two before he ran away,
When he was how old?
either 16 or 15. I think it was 16.
16 or 15?
Yes.
Which means that at that time, Nicole Nachtman would have been roughly 4 years old. She's 12 years
Yeah.
younger than him, correct?
So yeah, 3 or 4.
3 or 4 years old.
Yes, correct.
Okay, and so Joey calls you on the phone about this bus ticket, and this is when he tells you, this is why I want to leave, because they're abusing me.
Yes, he tells me he's running away. I said why. He answered those questions, told me specifics. It was pretty much they, but he said he was running away, and I asked him where, and he said, I'm just getting out of here. And I said, don't just go anywhere, come to Florida. I'll get your ticket, you just get to the bus station.
And at that time, that was a conversation on the phone between you and Joey alone.
Correct.
Nicole was not a part of the conversation.
No.
She would have been 3 or 4 at the time.
Correct.
And Joey never indicated to you that Nicole witnessed it, did he?
No.
Nothing further, Judge.
Anything else from the defense?
No, Judge.
All right, sir, I'm gonna ask you to step outside while I finalize the legal argument with the attorneys. All right, the witness is exited. Now, let me just be clear as to what the state had presented to me before. You expect that if he testifies to that you would recall Joey as a rebuttal witness who would say, absolutely not, that did not happen?
No, Judge, I'm objecting to that testimony.
No, I understand, but I'm
Altogether.
yeah.
I don't know what our plan would be to recall Joey. I mean, I guess we could do that, but pursuant to the case law that Ms. Hersey gave you, those 4 cases that she presented to you, all of these are cases, all of them, in which the defendant herself, testified that they either personally knew the prior acts, the gun, that the person had a gun, whatever it was, or that in the case of Quintana, that they personally witnessed the assault. So our position is this is way too far of a stretch. It is not reputation testimony. It is not based on a broad segment of the neighborhood or a broad segment of the community. It is hearsay based on hearsay without even specific acts that are known. So no, I believe that this does not fall under the cases that were provided.
You know, I hear you, and I'm ready to do this. I just wanted it to be out there just so that they know that if he was to testify to that, because I thought that Mr. Terry had disclosed something to us today, that he had talked to the witness, and the witness said that at all. I just don't remember the specifics of it. That's not the reason I left, or that is the reason, or that just didn't happen.
I suppose if the court were to allow that, yes, I suppose we would have to call Joey Carey to clarify some of those things, but I believe it's opening a can of worms at this point when it's way too far of a stretch and it's not consistent with what the case
You know, I mean,
provides.
you've got my attention on in all those cases. The defendant themselves testified. What we have here is his testimony that he's not sure specifically. Quote, that's what he testified to. And the other thing was just an assumption The same things happened without a description of what those same things were. It could have been anything.
Judge, I'd cite to Nelson v. State, which is 739 Southern 2nd, 1177, where the defendant did not testify as it relates to the knowledge. And I want to point out...
But what are the facts in that case giving rise to the fact that the defendant did have knowledge?
Well,
Someone testified that I discussed it personally with the defendant.
I'm sorry, Judge, that one was reputation in the community, which does not require the defendant's specific knowledge.
Correct.
Judge, I don't think there's ever, when reputation or character evidence is admitted in a self-defense case, there is never a requirement that the defendant testify. Only proof that the defendant knew about the acts. That's the only requirement.
No, but where does it come? It usually comes from, because defendants usually testify in self-defense cases, so it usually comes from the defendant,
Or
not
a
a
witness
requirement.
who was there and tells the defendant, as in our position is, that Nicole Nachtman was present, she came in, and in Eric Lear's opinion, she looked like something had just happened to her physically, or something had just happened, some confrontation with her mother had happened, and he said, the same things happened to Joey, you can tell me. Now, whether the court limits me and says I can't get into the mall incident or whatever, but that this individual has knowledge that Joey Carey was abused, and that Nicole, in fact, knew about abuse in general, then I don't think you limit it 100%. So maybe I can't talk about the actual key in the hand because he didn't say those words. Maybe I can't talk about running away. But again, to paint a picture to this jury, as Joseph Carey did yesterday, that everything with his mom is great, when he has testified under oath that she used to punch him in the face, make him bleed, the jury didn't hear any of that because we were limited in what we could bring up at that point because of self-defense. But that, again, is not painting the true picture to this jury, that everything was great, and oh, by the way, as Mr. Terry suggested, I didn't run away. I left Virginia. You got on a bus and went from one side of the United States to another because everything was happy and kosher is not the picture that this jury should get. That's our only position. And I believe we have established a predicate that at least Nicole knew something had happened between Joey and her mother in the past, and that goes to her fear and why she feared her mother on the day she killed her.
I hear you. I'm aware of the cases. It's just not enough. He may take us up to the pond, but I'm not prepared to jump in. There's just not enough. And his specific testimony was not sure specifically. I wrote that down. I underlined it. You went into some further details with him, particularly regarding the incident where he was assuming that she was talking about physical abuse, but he never confirmed that with her. He didn't know what she was talking about, so he didn't know what he meant when he said the same thing happened to Joey. He may have meant one. There's a disconnect, I guess, is what I'm getting at, and it's not enough. So,
Judge, I do also want to point out that if Joey Carey is recalled to the stand, and this is going to become a credibility issue, because that's ultimately what he's going to be called for, I guess to impeach what Eric Lear said, then I believe all of his physical abuse with his mother comes in, because if he's going to get up and say, no, that's not why I ran away, everything was so happy, and I just didn't like the cold weather in Virginia, I plan on then asking him, did your mom punch you in the face? Did she make you bleed? Did your mom put a key into your hand? And so, again, we're trying to try this case in a vacuum, and it's not a vacuum. So
you can't call a witness to impeach him.
if they call him on
if they call him.
cross-examination
Okay.
and open that door, my plan, with the court's permission obviously, is to ask about all those questions. Because if you're going to paint the picture that I left Virginia because I didn't want a winter coat and I was really cold, that's not why he left Virginia.
Based on my ruling, I don't know that they intend to call him as a rebuttal witness.
I don't know, Judge, but if we do, it's still not opening the door, and we can deal with that later
Well,
if we do decide to call him. Because he said, Eric Lear testified that he ran away from his mother. He's going to testify that he was not with his mother at the time. He ran away from his father. He was on a forced visitation with his father at the time. His father was the one who was doing that. His mother wasn't there at the time. He ran away from him, not from her.
All right, well, I'm not going to cross that bridge yet until I hear you request to call him as a rebuttal witness, and then I will address it.
Judge, based on the court's ruling, I do not need to reopen my direct of Eric Lear so we can
So we're
move
gonna
right
go to
into
the cross.
cross-examination.
All right, let's bring in, is the state ready? for
Oh, can
cross?
I let him know he's not going to be asked so he doesn't blurt anything out?
You absolutely can.
You want to come with me, Courtney?
Yes.
I'm sorry. 5:45.
All right, so is the state ready?
Yes, Judge.
Defense ready?
Yes, sir.
All right, obviously, we'll bring them in. Obviously, I'm going to take full responsibility for the delays as I always do, but it's getting hard to do. I think that the experts could legitimately call me a liar under these circumstances. But it's understandable that things come up that we have to discuss. Obviously, I'll ask them whether they had any contact or discussion or did any research. Who's the first witness? I intend to, after the cross, ask you to call your next witness who I
Dr.
suspect.
Heidi is first, Judge,
Heidi.
but however, I wanted to publish, not the whole interview, we never published Defense Exhibit 2, and because it's part of what she relied on, I'm gonna play the first portion of the interview.
Before you call her or while she's on
Yes,
the stand?
before I call her. Defense Exhibit 2, the interview that's been introduced.
After this witness, before they call the next witness.
Just gonna publish that portion with the assistance of my investigator and
What portion of Lieutenant Hamilton, or just,
the Snow Queen at the beginning.
are you gonna include the portion where she notes? or-
It's in the beginning. You can play whatever you'd like.
Yes, we are.
All rise for the jury.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. We are getting started a little later than we had expected. Again, I take full responsibility for any delays. Please do not hold that against the attorneys, the parties, or anyone else in this case. We are going to pick up where we left off. We're going to bring in the witness who was on the stand yesterday and proceed with cross-examination. We finished with the direct examination. Before we do that, though, let me ask, did anyone have any exposure to this case outside of the courtroom? And by that, I mean see any reports, do any research, or discuss the case amongst yourselves or with anyone else by show of hands? Let the record reflect no show of hands. Thank you all again very much. Let's bring in the witness who was on the stand. Good morning, sir, and welcome back. If I can have you come back down to the witness stand, I'll remind you that you are still under oath from yesterday.
Okay.
Go ahead and have a seat, make yourself comfortable,
Thank you, Mom.
and then I'm going to allow the state to proceed with cross-examination.
Good morning again, Mr. Mayor. The apartment that you mentioned that Nicole had during, I believe, her senior year at Sickles, do you know the address of that apartment?
Not exactly. It was Sheldon Road. That's all I know.
Sure. You never actually went to that apartment, did you?
Once.
On one occasion you did? And during the time that you went to that apartment, was Miriam Deans, her mother, present with her?
No.
Okay. The apartment that Miss Nachtman had that year, that apartment was prior to your sister, Miss Deans, purchasing the home in Carrollwood, correct?
I'm not quite sure of the events as in when she purchased one home or the other.
Okay. There was a period of time around that time when you were sort of estranged from your sister. Is that accurate?
Correct.
You all weren't really communicating and weren't really close at all.
Correct.
And it's fair to say that for a long period of time, you and your sister sort of had an off and on relationship.
Yes.
It's accurate to say that you did not agree with all of her parenting decisions,
Correct.
and that on multiple occasions you witnessed your sister reprimand her child when she did something wrong.
Correct.
You said yesterday that when she came to the mall with you and your family that she was around 20 years old.
She was in driving age. I think this is about it. Yes. Yes.
Okay.
Right.
And that she had to call her mom to get permission to go to the mall.
Correct.
But then you've also told us that she lived in an apartment at around 17 by herself. without her mom present?
When I went to the apartment, Mom was, I don't think she was even in town.
Right, so she was living there by herself, without her
Correct.
mom present?
Correct.
Okay. And you've referenced several times that Nicole was driving age. It's accurate that during the time she was driving age, she had a car, and that in fact is how she would come to your house,
Correct.
come visit you and Grandma.
Correct.
And that on several of those occasions, Miss Deans, her mother, was not in town and not present.
Correct.
Prior to going to the Air Academy, Miss Nachtman was an honors student. Is that accurate?
Yes, she had good grades.
And it's your recollection that at some point Nicole told you that she wanted to major in finance in college. Is that right?
No, it's not correct.
You don't recall that?
I don't recall that. She just basically told me that her mom made her change her, what she wanted to do.
Okay. Judge, can I have one moment?
Yes.
Thank you. Nothing further.
Redirect?
Yes, sir. Mr. Lear, Ms. Deary asked you about the parenting decisions that you did not agree with of your sisters.
Correct?
Would one of those be having Nicole get liposuction?
I was not aware of that till after the fact.
And then after, not something you agreed with?
Correct.
Was another parenting decision that you didn't agree with your sisters, sending her daughter to a boarding school when she was functioning fine in Florida with her family or in Tampa?
Correct.
You had mentioned yesterday on direct examination that when you were noticing changes in Nicole through her childhood, that you in fact told your sister or suggested to your sister that something be done or someone get counseling or intervene.
Yes,
And nothing was done, correct?
she left it off.
Is that another parenting decision that you didn't agree with that your sister made?
Yes.
And at that time, did you have power of attorney or could you make those types of decisions for Nicole?
No.
Ms. Deary asked you about, Nicole had this apartment by herself, but yes, she had to ask permission to go to the mall. Was it your understanding or was it your belief that it's a good parenting decision to have your 17-year-old?
I'm going to object as to his belief or opinion on that.
I'll sustain.
Ms. Deary asked you if you agreed with your sister's parenting decisions and if that caused some strife between the two. Do you recall that question?
Yes.
Is one of the parenting decisions you didn't agree with having your 17-year-old daughter live on her own when she couldn't even bathe or care for herself?
That was one of the issues with the apartment because when I went there, all there was a mattress. There was no furniture.
So when you didn't disagree with your sister's parenting decisions, these are things that you were seeing occurring with Nicole, and that's why you were not agreeing with her parenting decisions.
That was our fallout.
It wasn't about she got Nicole a car, and I don't think Nicole should have a car.
No, not at all.
It wasn't she bought Nicole a computer, but I didn't think she should have a computer.
No.
Your concerns with your sister's parenting decisions involved Nicole Nachtman's well-being.
Correct.
Ms. Deary asked you about times when Nicole would drive herself to your mom's house and your sister would be out of town.
Correct.
Were there also times when Nicole would be at your mom's house, your sister would call, and she would jet out of the house without even saying goodbye to anybody?
Yes, plenty of times. We didn't even know my sister would call. We would wake up in the morning and the front door would be unlocked, and she just left in the middle of the night. So, but that happened multiple occasions. Sometimes in the middle of the night, sometimes in the middle of the day. She wouldn't even say goodbye. She would just dash out. Sometimes she'd be dropping stuff. She wouldn't even turn. It was almost like a panic to get to her car and get going.
And that would be in response to your sister calling
Yes.
for whatever reason.
Yes.
Was there a time where Nicole shared with you instances of how her mom was treating her abuse and some time where you reported that to your sister?
Yes. Nicole called me out of the blue one time.
I'm going to object to hearsay.
Judge, if we can approach. Is it fair to say that anytime you express concerns to your sister about anything pertaining to Nicole,
Yes,
you saw no action?
yes.
If I can have a moment?
Yes.
I don't have any other questions. Thank you, Mr.
May this witness be excused by the state, by the defense
Yes, sir.
and the state?
Yes, sir.
Thank you, sir. You may step down. You may be excused as a witness at this time. And before the defense calls the next witness, I believe you have,
Yes,
one of the
Judge, I'd like
exhibits you
to
wanna
publish Defense Exhibit 2.
That is in evidence.
It's already in evidence.
You may publish it.
I'm sorry.
Let me have the attorneys approach briefly before you publish that.
Judge, permission to publish Defense Exhibit 2.
You may publish.
Do you need to go to the bathroom right now? They're gonna get you a bottle of water. There's another detective that's gonna be sitting there, I'm gonna ask you that.
Judge, can you just inquire, make sure everyone can hear?
One of the jurors and the two of the jurors in the back cannot hear. Let's,
I mean, it's a normal response.
Oh, a little bit tired. Did you drive all,
Yeah.
and I heard the something? What's the story of the smuggling?
The story by the book version is that, these trolls have a mirror that turns everything ugly, and they tried to get to heavens, and it shattered, and anything that got into harder eyes, they only see or felt ugly. And it got into this one boy's hardened eyes, but he was playing with his best friend, Gerda, this girl, and so he broke their flower vase, and then ran off, and then the Snow Queen cabin came by and whisked him away, and Gerda went on a search to go save him, giving up like her shoes, her coat, but she was in a because she was in a cell, the storm searching for him was only a dress and a summer dress and bare feet. And, you know, she finds them, apparently supposed to move these pieces and spell eternity and be set free and given a pair of skates or something like that. Of course, nobody's not alone there for some reason. And, so she cried on him and his chest, pieces fell out of his chest. So he, you know, then he starts to cry and the pieces fell out of his eyes. And so we start dancing and the pieces somehow from the movement floor merged to spell eternity. And, then, you know, and then he was free, of course, but nobody didn't come back. He went, he did pass him on. And I guess it was happily ever after. And she made a lot of friends, or sort of friends. I mean, she met James her away. She met, you know, a summer witch, trying to keep her there. She met a thief friend who she managed to turn around to do something good or something like that.
A thief friend?
Like a thief, like that. And she met the girl captured her, you know, and all that stuff. And, you know, this, you know, hearing her story, which is a little bit, I don't know, from a reader's perspective, it's kind of like, I don't want to say bland, but something close to that, and undeath or something like that.
What was the moral of the story?
I actually, I don't know, I was still thinking about that.
Excuse me, just a second. Let's see about that letter. So this is what you read personally?
I read it online, yeah, I have it online, but I always like my version of my story better. I like to write about the snow thing about my own version.
Oh, so you're writing?
I like to write. I didn't do the writing about it, but I like to imagine it because you can't really write about filthy based on that. It's kind of complicated. You know, it's completely illegal. You know, like that. But something in my book, in my version, is that she's actually always benevolent. Because just because she's benevolent, it doesn't mean she's always right. You know, she'll help somebody in aid, but this person might be a bad person, but it's not her. It's not her day, or it's not her call or judgment, or she's not the executioner or any of that.
There you go.
And she has a Midas touch, which, you know, instead of turning to gold, it turns to ice. So everything so she always has to walk on snow unless the earth turns to ice. And she holds infinite knowledge. I mean, but she only gives out so much because, you know, in the wrong hands, it can be, you know, dangerous. So while she might be emotionless and seems uncaring, she's very benevolent. She just, you know, she's just not there to see people. She'll help. If you're in aid, she will assist. But the only reason why she doesn't aid, as she is not like a superhero, because when things go down and people are stressed, then they always blame the person they got the idea from. You gave me this idea, you told me I should have done this. I said, most people do this and this, or she just gives it more her knowledge, doesn't give advice, or she tries to.
Not much an opinion.
Yeah, she doesn't give her opinion because it will, you know, it's not like it mean anything, she does backfire, but it can't affect her, it can't touch her. But, for their benefits, like, I give you this knowledge, what you do with it is your own choice.
Right. Nicole, I want to confirm a few things with you, but I'd like to record our conversation. Is that okay with you?
Yeah, but, I would suggest to hold all questions until you get a lawyer or something like that. I see in movies, do you mind?
No, that's strictly up to you.
Yes, please, I would really appreciate it.
Okay. So you don't want to talk about attorney presence?
Yeah, that'd be probably best.
Okay. All right, okay. Consider your order. Take a call.
So the snuff scene, she takes different forms, but she's all like, she's white as snow and gray, and I mean, she doesn't really have a shape or anything, but I would like to imagine it.
You were, I'm trying to figure out the Snow Queen. This is a book you read?
The book you read, the one I'm talking about right now is my own version, because I didn't care
As
for
I
the
say,
book. Yeah.
does it relate to you in particular?
No, actually, I don't think so. I mean, but then again, if you think about it, when you read a book or a character, you're always drawn in by character similarities.
Well, that's what I was going to say. Is that
Defense ready to call your next witness?
Judge, a couple of exhibits I'd like to introduce with no objection, I believe, from the state.
Ladies and gentlemen, jury, all of the items entered into evidence will be available to you in the jury room when you deliberate.
Judge, I'd like it now to introduce Defense Exhibit 7, which are the liposuction records.
Is there any objection?
No objection.
They'll be admitted.
Permission to publish.
You may publish.
And I don't know if it's easier, Judge, if I pass them around for the jury to look at.
It's probably with
Judge, the defense now calls Dr. Kathleen Heidi.
Dr. Heidi.
Judge, can we approach briefly?
Yes.
While she's coming in.
Dr. Heidi, good morning and welcome.
Good morning, Judge. Thank you.
I know you've got your hands full. I'm going to need to swear you in.
Oh, yes, sir.
Can you raise your right hand?
Absolutely, sir. Okay, Judge.
Doctor, do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, Doctor. If you'll follow the bailiff around
Okay.
to the ramp, please watch your step. I know that you've got a lot of stuff with you. If anything you need to unpack, you're welcome to do that. I'd like you to have a seat, make yourself comfortable, but anything you need to unpack, the microphone is adjustable. And then if you'll just let me know when you're ready, I'm going to allow the attorney's opportunity to ask you some questions.
All right. Thank you, Judge. All right, Judge, I think I'm ready. Thank you very much, Judge.
All right, you may proceed.
Introduce yourself to the jury, please.
Good morning. My name is Dr. Kathleen M. Heidi, and I'm a professor of criminology at the University of South Florida, and I'm also a criminologist and licensed mental health professional.
Explain to the jury what a licensed mental health professional is.
A licensed mental health professional, there are several categories. I'm licensed as a mental health counselor, and in that respect, I can assess, diagnose, and treat individuals that are referred to me. And my practice consists particularly of evaluating individuals who've been, particularly juveniles, adolescents, young adults, who have been charged with very serious crimes, typically murder. And then in addition, I also treat survivors of trauma, and that would include individuals who have a history of child abuse, perhaps sexual assault or other crimes. And then importantly also, I treat police officers who've been involved in trauma. And that would include, for example, being involved in a police shooting or going to a call where a child is killed, or having a comrade, a fellow officer die in the line of duty, or being the first one on the scene of a fatal car accident. So those are incidents of trauma that I also treat and have been licensed since 1991.
You mentioned a professor at University of South Florida in criminology. How long have you been doing that?
I have been a professor in criminology, a full professor, since August of 1981. So in August it will be 38 years.
And just briefly tell the court the jury what criminology is.
Sure. Criminology is basically the study of crime and criminals, why people commit crimes, and then what to do with them, how to treat them, how to intervene. It also takes, of course, into account the law. That's very, very important.
In addition to your being a licensed mental health counselor and a professor of criminology, did you do any particular research in the area of psychology, graduate hours, and things like that, if you could explain?
Yes. When I was in, my degrees are from bachelor's from Vassar College in psychology, and then my master's and doctorate is in the area of criminal justice, and that's from the University of Albany, State University of New York. And when I was there, I took coursework in the psychology department, and then I also majored or specialized in theories of crime, particularly psychological theories, and I did personality of assessment of offenders under a federal grant, working basically for the federal government, though I was a student. And then in addition, sorry, I just lost my train of thought, it'll come to me. I also took courses, in mental health law. So that was my area of specialization period, essentially psychological assessment, psychological theories.
Within the field of psychology, mental health counseling, do you have any specialized training in certain areas within that field?
Yes, in particular, certainly in assessment and therapy, forensic evaluation, but I also have quite a bit of training in child abuse, neglect, domestic violence, treating trauma, and then also what we call antisocial behavior, which could include personality disorders and things like that.
What expertise do you have or experience do you have in evaluating adolescents and young adults charged with violent crimes?
I would say extensive experience. I've been involved in evaluating juveniles, adolescents, and young adults who've been involved in murder, attempted murder in particular, those two, since the 1980s. So to date, I would say I've evaluated over 150 individuals who've been charged with violent crimes. And here I'm talking about particularly young people, and particularly with murder and attempted murder.
What about young adults or adolescents who are specifically accused of killing their parents?
Yes, I've written extensively about my research, and in addition, when I say those 150 cases of individuals charged with murder, attempted murder, 50 of those are individuals who killed parents, and sometimes that includes a step-parent, but basically a mother, father, or step-parent. And in some cases, the defendant or the individual, the child involved in quotes, has killed both parents.
And did you in fact write a book and explain to the jury what parasite is?
Yes, I've written 4 books, and I have about another 100 scholarly publications. 2 of my books of the 4 dealt specifically with parasite, that means the killing of parents. My first book, which was published in 1992 by the State University, Ohio State University, was called Why Kids Kill Parents, and that was considered the seminal work at the time because no one else had looked seriously from a scholarly way at that. And then in 2013, Oxford University Press published my second book on parasite. That's called Understanding Parents, Why Sons and Daughters Kill Parents. And that book really talks about what I learned in the 20 years since the publication of the first one. So those books are widely used in the field basically to talk about what we call the phenomena of parasite, or children, whether they are under 18 or adults who kill parents.
Your work with regard to, I believe the term is parasite offenders, children who kill their parents. Is that the accurate term?
That's the term that's commonly used, Mrs. Hersey.
Is your work in that area strictly confined to the state of Florida, or have you also worked in other jurisdictions?
No. When you publish in an area, very often people come to know your work. In fact, my work's been cited over 3,500 times. So scholars and then lawyers will become aware of it. So I have evaluated parasite offenders in 16 states and also in Canada.
Judge, at this time, I will tender Dr. Heidi for any questioning by the state.
No questions. Take your seat.
You have a lot of stuff in front of you,
Yes, Mrs. Hersey.
so tell us what you have and what you've reviewed, and again, generally, as it relates to materials in regards to Nicole Nachtman's case.
Okay, I would estimate, and it's really an estimate, probably about 3,000 pages of documents. Now, I've been involved in this case since 1985, within a few days of Nicole being arrested. So I've reviewed.
Did you mean 2015?
Did I say, I'm sorry, 2015,
Okay.
yeah, 2015, so 4
You
years.
had me worried there.
Okay, no, thank you, Counselor, for correcting me. So since 2015, and those would include, as I said, about 3,000 pages. That would include police reports and documents of the investigation, court reports that go to the parents. The parents were involved for many, many years in a custody battle. Memory, but my memory tells me I read about 8 depositions of family members, and then I read depositions of 4 students from Florida State University. 3 of them were girls that are young women that knew Nicole well, and 1 was, I believe, a young man that was also from Florida State that knew her. So I think, and then I read, and there must have been 500 pages of jail medical records. So I think, and then, oh, one other thing. Then there have been some other experts that have been involved, and I did read their depositions, their sworn testimony, and I did view an evaluation by a doctor that was videotaped. So I think I probably covered, Mrs. Hersey, the bulk of what I have done.
With regard to the videotape, was that a video evaluation that the state doctor, Dr. Lazaro, had conducted of Nicole?
Yes, ma'am, that's correct.
And in fact, that entire evaluation, about 14 hours, was actually videotaped, and you reviewed that in its entirety.
Yes, I did.
Let's talk about when you first met Nicole Nachtman and how close in time to these offenses did you go see her?
I met Nicole for the very first time on August 28, 2015, and that was in the jail. I saw her twice on that day. So my understanding is that the second homicide happened on August 20th, so I would have seen her within 8 days of that.
And that would have been at the Hillsborough County Jail.
Yes, Mrs. Hersey.
And how many total times do you believe you've seen Nicole over the past 4 years?
I have seen her 13 times.
Did you also interview any family members in relation to background information or family history as it relates to Nicole? And if so, who were they?
Yes. Shortly after the incident, I met with Joe Carey, who is her brother, and I believe I met with him on might have been September 8th, so it was very close in time again to the incidents. And then I met with Mr. Nachtman, Nicole's father. I met with him on September 25th, 2015, so that would have been about a month later. And I should mention Mr. Nachtman, prior to that, had contacted me, so I also had a voicemail phone conversation that I listened to, and an email from Mr. Nachtman, and he contacted me because he became aware of my research. He did not know I was involved in the case.
You also authored a report in this case, is that correct? Documenting your findings, your review of records, testing, and things like that.
Yes, Mrs. Hersey.
So let's talk about how old Nicole was when you met with her in 2015, her chronological age.
Nicole at that time was 21 years old. She had been born in February '94. I met with her in August of 2015, so she was 21.
And that makes her how old today, approximately?
Well, today, she is 25 years old today. The last time I met with her, she was a little shy of 25. That was January of 2019.
Can you just explain to the jury what the process is you go through when you go see an individual like Nicole? And just so we're clear, obviously our office contacted you and asked you, based on your experience in this area, if you could go see Ms. Nachtman and do an evaluation. Tell the jury what that entails when you go and see a client for the first time and what that assessment entails.
Well, what I do in every case is I want to get a clear idea of how that individual is functioning, how they're perceiving events. So the closer to the incident, of course, the better. So I do what I call a semi-structured clinical interview. What that means is I ask more or less open-ended questions. How are you feeling? Tell me what happened, and then I do follow-up questions. Then I also am asking about her social history. What that would include would be things like, her family and perceptions of her family, school, work, drug, alcohol involvement, also friends, boyfriends or dating history. So I want to get a sense of sort of what her life is like, activities also that she might be involved in, of course, is very important. Her mental health, I'll ask her what she knows about that. She's been to any counseling. I'll ask about her physical health. So I'll ask a lot of questions just to get to know basically who she is. Then I do this in every case, but in a case of a child that's killed or an individual who's killed their parents, it's critical. I do a very complete assessment of childhood maltreatment. What I mean by that is I ask specific questions that are designed to evaluate whether somebody has been abused, like physically abused, verbally abused, sexually abused, psychologically abused, if they've been neglected, like physically neglected, medically neglected, emotionally neglected. And when I say I ask specific questions, and this is really important, I might ask, for example, a question like, did a parent ever hit you because they were very angry? Did a parent ever shove you? I wouldn't ask somebody, have you been physically abused or have you been sexually abused, because they may not know what that means. So I want to basically ask what I call indicators of those different types of abuse and neglect. And then if they indicate something, yes, my dad or my mom did hit me on when they were very angry, then I would ask for details. Well, can you tell me what happened? How many times do you think that happened? So I do that child abuse and neglect. Then I also, of course, ask about the incident, essentially the crime, criminal event, and I assess their mental status, sort of what they're like at the time that that event is happening. And then what I try to do, and usually I can do this, is explain how this came to be. Just what factors might have led, say in a parricide case, a son or a daughter to come to take the life of a parent or both parents.
You had mentioned earlier it's critical to evaluate an individual as close in time to the events or the offense, and I believe you said earlier you saw Nicole 8 days after her mother's death. Can you
Yes.
tell me why that is so important?
Yes, because if the clinician can get in quickly, you're getting a sense of how that individual is. If the passage of time is significant, you run the risk that the person, say if they were in a very mentally disturbed state, has calmed down, maybe in a different place. You can also run into some issues where memory can change over time. So the sooner the clinician can get in, the better, to basically get a pulse on it, to see, how they're behaving, how they're perceiving, how they're feeling. Are they emotionally upset, or are they, zoned out? So that becomes very, very important, and I think that would be commonly agreed in the field, to get in as soon as possible, when it's possible.
Judge, can we approach briefly?
Yes.
Is your microphone back on?
Yes.
Okay,
Okay.
I'm on.
Tell the jury what your observations and conclusions that you drew during your evaluations of Nicole with respect to her level of functioning, any history of child maltreatment, or any other traumatic events.
Okay, those are a lot of questions, so let me start.
Let's
if
break
it's
them
all right.
down.
Yeah.
Let's talk about the behavioral observations you made
Oh, okay.
of
All right.
Nicole during that
Yeah.
first evaluation
And
in
I'm-
2015.
All right, I'm just gonna get my notes just so I can just refresh my memory. All right, when I met with her the first time, that was August 28th, 2015. I actually met with her twice. I met with her in the afternoon for a few hours, and then later that evening I went in. So I met with her about 6.5 hours that day. And what was immediately apparent, she was in a suicide gown. And that was because the jail was understandably concerned that she could possibly cause some self-harm, and she had made some indications that were consistent with that concern. She was oriented to what's called person, place, time, and situation. What that means is she knew she was in jail. She knew why she was in jail, that she had been arrested and it involved the killing of 2 people. She also was aware of, basically the time period it was, and that, she was charged with these incidents, and her name was Nicole Nachtman. She was depressed when I first saw her. She wasn't sobbing, but you could tell by the affect. She looked very sad. And then what I noticed, and this is very interesting and very important in diagnosis, the affect changed. At times, she was somber, which you would expect. This very serious situation. But then she went from being somber to being animated. And I remember as I was there for 6.5 hours, I couldn't help but notice at times it was like she was a little child, giddy. She even told me some jokes which weren't funny, but more importantly, it's completely inappropriate. This is a 21-year-old who's been charged with 2 serious crimes, and she's like a little kid telling jokes to me. And she knew, by the way, that I was a doctor and why I was coming in and that I would report to the defense, so she was aware of that. So I noticed this very kind of giddy child. Then she became almost like an adolescent, very animated, telling me about anime and the stuff she did, like we were kind of best friends. Then at times she started to stutter and she became very anxious. So I saw those particular types of behavior which were kind of, if you want to say, you might use the word bizarre because of the context. This is very serious, as we all understand, and she's at times being very childlike and like forgetting or just being unaware or just not plugged into what we're talking about here is very, very serious. Now, so that bizarre behavior is important. Then speech, I noticed, and it was very apparent. Normally when you ask somebody a question, and if it's not a real hard question, they can answer it. You know, you just give an answer like, you know, where did you go to school? And you say, I went to USF or FSU or wherever you went. But Nicole had trouble answering a simple question. Now, she was being cooperative. She was very pleasant, but she was going into all this elaborate, excessive, unnecessary detail. And we call that circumstantial speech. And that just means, again, she's going into all this excessive stuff, and it's taken her a long time to kind of get back to what we were talking about. Then there were other times where I would ask her a question, and we call this tangential speech, where she'd just go off and she never came back. And I'm there, and I know she's trying, and I'm trying to understand her, but it's a rambling, and it's not always making sense. So this tells me there's something going on with her, a disturbed thinking process. Now, I've also noticed her long-term memory was what I would characterize as very poor. She couldn't remember basic things, and I'll give you an example. And I don't know if you know this, but Nicole has 2 brothers. She has a brother named Joe, and she had a brother named Kevin. Kevin, and Nicole is the youngest. Kevin was in the middle. Kevin died tragically in a car accident. Now, Nicole was about 9 or 10 years old. She may have been 10, I don't have the exact date, but she was at least 9 years old. She has no memory at all of her brother. And that struck me as odd. There are other things she doesn't remember, but to me that was pretty extreme. When I say other things she can't remember, like Christmases, gifts, and things like that.
Dr. Heidi, I want to stop you briefly. Because while we're talking about this inappropriate affect you've described, the rambling speech, talking about things that really weren't pertinent to your conversation, did you also have an opportunity, because I didn't ask you this when we talked about materials, to review a jail visitation with her brother shortly after the arrest and the police interview at the Florida State Police Department?
Yes.
And I bring those up because was there any evidence in those kind of supporting what you're observing of her during that first meeting?
Yes, thank you. Yes, I reviewed both of those. The video visit with the brother, I think, was actually a couple days after I saw him. And what was, again, how can you say, alarming maybe, but clearly indicative of severe mental illness, is that she's talking to him and she's laughing, saying, I did it, and basically does not seem to grasp it. This is really serious. So she even says, and she's very excited to see him. She really does have a strong love and affection, and she had talked to me about going to her brother's over the summer, and she's done this for years, and she calls him Joey. So she says, I can't wait to get out. I'm going to buy you, and he has 2 little ones, 2 children, I'm going to buy you all gifts. And you watch this and you go, she doesn't seem to get what is going on. Now, when I watch the police interviews, and they're very long, it's 10 hours. Nicole was in police custody for 10 hours. The police start off talking, and there are 2, but one of the men that stays in strikes me as a very pleasant individual. Nicole has told them, based on what her family has advised her brother, not to talk to the police in terms of the incident. So she tells them that, they're very respectful. And they talk to her. And now remember, she's 21 years old, she's a college student, she's charged with 2 counts, or she's not charged at that point, but she's there because 2 people have been killed, and she's there in terms of the investigation. And she knows that. She's telling them jokes. She gives the officer a riddle. And then she goes on and on about talking about Anime, the Snow Queen. And she then talks, remember this is 10 hours, there are breaks, and I'll tell you about those. But it's like these characters are real to her. She writes stories, and as I'm listening to this and I'm watching her, she's very completely at ease with this police officer, who again is very pleasant, very nice. He listens to her, and you'd think it was maybe like a grandfather she's talking to when she was a little kid, rather than a 21-year-old talking to a detective. So she goes into all this detail about these characters, and they sound like they're people that she knows. Then when the police officer, the detective, leaves the room, and he does several times, she's left alone, and her whole demeanor changes, and you can see this, it's very apparent. She now becomes anxious, and she has a sweater on, and she's kind of wrapping it around, and you see her pacing. She gets on the floor, she gets perches on the chair, she can't sit still basically. And then she tells the police officer when he comes back, she says something like she's tired and she'd like to go to sleep. Police officer, the detective, says that's fine. He said, do you want me to leave? She says, very docile, very pleasant, almost again like a child with authority on this respect. She says, no, you can stay. And she lies on the floor. At one point, and again, it's interesting to watch, again, she's always wrapping this sweater around her, and I'm kind of thinking, is she cold? Is it, a nervous thing? Is it a security thing? I don't know, but she does that. She gets on the floor. At one point, she even puts her head under the table, and what she's wearing is a gray sweater. It's a gray carpet, almost like she blends in. So you see this. Then when she's up, she at times is kind of like picking at her skin. And what I make of this as a clinician is that she's dissociated. What dissociated means is she's not dealing with what's going on here. And what's going on here is she's basically under investigation for killing 2 people, and she's just talking. She's, again, very polite to authority, and I want to mention this because it's significant in understanding her. Whenever the police officers do anything for her, they bring her in a piece of pizza. She's very appreciative. One of the officers says to her, it's not the same one, I don't think, it's a different detective, says something like, I'm really sorry this happened, this whole thing, meaning the killings. She thanks him for saying that. But again, in watching that, I get the sense is she's just not dealing with the gravity of this situation and how serious it is.
Dr. Heidi, when you were And again, I brought that up because you were talking about what you were observing during your first interview with her 8 days. Was it consistent with what you observed in both of those videos?
Absolutely consistent, yes. The inappropriate behavior, we might call it bizarre behavior. Bizarre meaning, given what's going on, the context, this behavior for a 21-year-old college student, she was 7, 8 years old. Very different situations, a 21-year-old college student.
Going back to your behavioral observations during that first interview in August of 2015, I think we had left off on the fact that you believe she had poor memory when it came to her childhood and some of the things she was reporting. So we want to, what other behavioral observations did you make?
Okay, and again, going back to that first meeting with her, she was anxious. At times she stuttered, but I want to underscore she was always pleasant to me. She was cooperative. She wanted to answer the questions, never refused to answer anything. Sometimes defendants or, offenders, whatever, will be somewhere hostile or irritable. Not with me, but there was a little, what I would call veiled under the surface anger towards her mom. And it was really important to her, and I think it has been consistently, with me and everybody else, that we see her as a good kid, that a nice person. And she said throughout all the clinical interviews, but this sense is this how she sees herself as a really good kid. And she wanted me to know that she's really a good kid. She follows the rules. She doesn't smoke. I mean, these are things she was saying, I don't know if she said at that interview, but that idea, I don't smoke, I don't drink, that type of thing.
What evidence did you see during that interview of any psychotic thinking or processing? Excuse me.
Well, definitely what I'm calling the bizarre behavior. Given that she's in jail, jail or in the police station, possibly or at that point charged with murder, 2 counts. So it's bizarre. The other thing is the disordered thinking. She's, and it shows her mind is not processing information well. It's like all this stuff is coming in, all this information. She can't basically think straight. So I'm seeing that, and then we will, I imagine, get into this. She has this delusion, and she tells me, well, I'm going to call it a delusion, but she tells me right from the onset that, and she's been very consistent throughout the almost 4 years, 3.5, that she killed her mother because she was afraid her mother was going to kill her. And again, this what I would call a delusion, because I saw no evidence that the mother, was the type of individual, or based on the history, that would have killed her. But her mind, and this is what is important, and this is why you want to do an assessment and how the individual thinks. Her mind is that her mother was going to kill her because of a number of stressors, which we'll probably talk about. So that's a delusion. So I've already talked about that. Then I didn't mention, I don't believe I did, when she came in, she looked unkempt. What I mean is, I don't believe she had showered, though she would have been, well, I don't know, maybe she would have been able to the first time. I shouldn't say that. She would be able to shower at some point. She may not have been able to, but that was the sense. So she looked, her hygiene was not good on the first meeting. The second meeting, a few days later, I can go into, maybe just briefly. She wasn't in the suicide gown at that point. And this interview, now, she did get visibly upset, unlike the one on the 28th of August. This is now September 5th, 2015. Again, she was actively engaged, again, very cooperative. If I asked her something, she's more than willing to tell me. Again, couldn't answer the question directly, took a long time. However, this is what, again, I've had, at that point I had more than 30 years working with college students. I mean, when I've taught large classes, I've had at least 15,000 students that I've taught. And I'm watching this incident where she's supposed to talk to her brother, but she can't seem to figure out how to do that. In other words, it's visitation and how you go about it. It's like a video visitation. You have to make an appointment. So she's telling me the deputy wouldn't help her. So I think at that point where we were in the location, I think I was on the pod at that point. So I called in, or I asked the deputy, would she come in, and she did. And I said, would you please explain how this video visitation thing work? Deputy was very nice. She's going through explaining to Nicole how this works. And Nicole's saying, nobody helped me with it. The other person wouldn't help me, nobody, and I go, Nicole, this deputy's helping you. Deputy's been very nice. So I said, let's just listen. So then I repeated it to Nicole, this is what you have to do. Deputy comes back in a few minutes, she said, I put the form on your bunk. Very nice. And so when I left, I just didn't have the sense she could do it. Just navigate. And that's not tough. You can say, oh, she's never been in jail before. True. But somebody who had a good thought process should be able to follow simple directions, particularly when it's not that complex and this deputy has explained it, explained it to me, we went over it, and so that was another observation I made.
I want to go back real quick just to the August of 2015, 8 days after behavior observations. We talked about delusions or psychotic thinking, her delusion that she feared her mom was going to kill her, even though you don't believe that to be true. What about any description or evidence about signs from God, auditory hallucinations, and those things?
Yes. From the very beginning, Nicole reported to me that she had, she didn't call them auditory hallucinations. She said that she had heard screaming in her head. She said it was about a year prior to the incidents. But this screaming was in her head. She said maybe it was her voice, but she definitely heard the screaming and it was getting louder. And then she said, and this is always a good thing to do as a clinician, is to ask, did it ever get better, ever get worse? Did she have any control? And she said, well, when I was at my grandmother's, her maternal grandmother's, and she had a nice relationship with her, she said, yeah, it was better there, but in the days before, the stressors are mounting, and I imagine we'll talk about that. She said the screaming was louder in her head. I would characterize that as an auditory hallucination. She said that when she shot her stepfather, she was hearing it, and then after she shot her stepfather, the screaming dissipated. And then she heard it subsequently when her mother came back in that time period. So it wasn't continuous. Now she also said, and I can get you I have all my clinical notes here and I can get them for you, but what I recall very clearly is she said when she shot her stepfather, there was thunder, apparently it was quite loud, and the thunder, she believes, covered up the sound of the bullet, so the police did not come. And she thought that was a sign from God. I think that's what she references, because she does believe that God is helping her, that it was a sign that God was protecting her. Then, as I mentioned, when her mother comes in, she talks about this rain. It's like when her mom is there, it's raining. When her mom leaves, it stops raining. That's again another sign to Nicole. So when Nicole shot her mom, the sky opened up for her. So she's taking this as another sign that somehow this is okay and she's gonna be okay. Then she tells me she goes to school, and I may have to get exactly this framework, but she goes to school, she's driving to school, and she gets, this is after the shooting of her mom, she goes to Florida State.
Oh, wait, hold on one second,
oh,
Dr.
did I-
No, you
Oh.
didn't. One of the jurors needs another pin.
Oh,
And,
I'm sorry.
So, no,
Oh,
that's
okay.
fine.
Okay.
Judge, can you also inquire when to let us know when they need a break?
I was gonna say,
Okay.
I was gonna take a break at 11:15, so another 10 minutes, unless somebody needs a break right now. We'll take a break at 11:15.
Okay, thank you.
Okay, so we were at Florida State University, and she gets there and she sees, it may even be on the way. I'm gonna, if you don't mind, I'd like to just see if I can find it for you.
If it'll refresh your memory.
Yeah. Let's see. Okay, it's gonna be here. Here it is. I've just found it. At one point, she's saying here that the expression "just do it and have faith in Jesus" crossed her path, and then she talks about the weather. Now there is more about signs. Here we go. She referenced the thunder. And then there is now I'm going into some of the other signs. I'm going to go by memory, and then I can find it on the break, Mrs. Hersey, if I need to. But it was when she's at the Florida State University, she sees a sign that you're one step closer to your dreams. It's something like that. Now, how I would interpret that is it's a message to college students that, you know, you're doing the right thing, you're going to college, you know, you're making progress. It's a motivational thing. To Nicole, it was, and remained for a long time, a sign that she was on the right course of action. That essentially, at times she says God, at times it's just sort of, I'm saying the universe, but she's getting these signs that she is on the right course of action, that what she's doing is okay, appropriate, and later at some point she even says understandable, because she also mentions, and I can go through each one of them from different interviews at some point, but she says when she even has these nightmares, it's God reassuring her that what she did was right. So, again, it's how she sees things. A healthy person would not interpret those sayings or the fact that there was thunder or that the sky opened up as God basically protecting her. One other sign I can remember that she mentioned right then, day of the homicide or the evening, she left after she shot her mom. And she left her car a distance away, so she had to walk to her car. And she said that she couldn't run, and that was partly a physical thing. She just wasn't able to run. So she walked, I assume, briskly, and she saw the police cars going right past her. And she said that was a sign from God that he was protecting her. So again, this is her thinking. So if you look at, in terms of psychosis, or you look at really somebody being severely mentally ill, this fragmented thinking, this can't answer a question, these delusions, these things that don't have a basis in reality, meaning her mom is going to kill her, these signs that God is communicating to her that what you did is okay, and I'm gonna protect you. That's in her mind. And so those are some of the indications that I saw from the very first interview that I would characterize as indicative of severe mental illness. And that has, the fragmented speaking, or what I'm saying, that the inability to answer questions has continued, with the exception it got better when she was on Prozac, which is an antidepressant, anti-anxiety. It helped her, let me say as a clinician, she still talked a lot, but she could be redirected more easily. So I could say, Nicole, hold on a minute, let me ask you this. So that helped her, but other than that, that's been constant. The delusion she's never backed off of, and I've asked Mrs. Hersey, I want to show something, a clip where she just, when challenged, she is steadfast that she was in fear of her life. That's a delusion. And the signs, I checked this last night, the signs continue to the last time I talked to her, or maybe the second to last, in December, right before Christmas, and I'll reference that. So again, these are signs that I would call, that other clinicians would agree, are severe mental illness, and certainly consistent with her being, as I talk about in the report, being in a psychotic break at the time she killed her stepfather and her mother.
Is there a term for these delusions? I don't know that.
Yeah, there are. The delusions.
Or the signs?
Yeah, yes, the signs are often referred to as referential, meaning that you think that they're referring to you. So that it's like special meaning, like God is communicating, or the universe through this sign, to tell me a special message that's not meant for everybody else. It's my message. And then the delusions of her mom, she sees her mom as unaccepting. Whether you call that as persecuting, I don't know, that's maybe a little extreme, but it's clearly a delusion.
Judge, I think this is a good time to break.
Yes, it is.
Okay.
Absolutely. Ladies and gentlemen of the jury, we're going to take a 15-minute break. Then when we come back, we'll go up to approximately 12:30 and take our lunch break. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid any exposure to any reports about the case outside of the courtroom. All rise for the jury. Jury is exited. Everyone may be seated. Doctor, you may step down. We're going to be on a 15-minute break. Please do not discuss your testimony with the attorneys, with anyone, unless all the attorneys are present.
Okay. Judge, just real quick before she leaves, Mr. Terry, initially when I began my exhibit list, he had indicated he wasn't going to have an objection to the video evaluations of Dr. Lazaro coming in, as long as I didn't play 15 hours.
Yeah, exactly.
So I made clips. I don't think there's any disagreement as to the authenticity. I didn't alter the videos. You can see Dr. Lazaro and Ms. Nachtman there. The reason I want Dr. Heidi in is because I had planned on playing some of those, but he just informed me he's now objecting to those. So before I do that in front of the jury, I can tell the court that both of my experts relied on the video evaluations, viewed them. There is no dispute as to their authenticity because the entire thing is videotaped, and I'm the one working the video camera. Dr. Heidi, can you just hold on one second?
Oh, sure, I'm sorry.